Welcome everybody to this afternoon's webinar on the mediation peer exchange, focusing on Lawyer for Our Day programs. The Housing Alliance of Pennsylvania is a statewide coalition working to increase access to safe, decent, and affordable homes for all Pennsylvanians. And we work to fulfill our vision for home within reach through state and federal policy advocacy, opportunities to connect, share, and learn from your peers, events, and our annual Homes Within Reach conference. If you're not a member yet, we ask you to please consider joining. You can visit our website to join as a member, and you can contact info@housingalliancepa.org for more information on membership. Just a few notes about today's webinar. It'll be about 60 minutes, including question and answer. If you'd like to pose a question to the presenters, please use the Q&A function so that the presenters will be sure to see it. And as you can see, the meeting is being recorded, and we will email you a recording of the presentation as well as any associated materials in about a week's time. Just wanted to let you know about some of our events coming up in the next few weeks. The first webinar is coming up is next week, next Tuesday, on solutions to address evictions, where we will hear from two people administrating successful eviction diversion programs in Chester County and in Reading Berks County. And the week after that, we will be kicking off the Housing Alliance's voter registration and engagement initiative. That's Wednesday, May 18th at 11:30. I did want to make a note that starting on July the 1st, the Housing Alliance will revert to our practice previous to the pandemic of providing free webinars to paid members and charging non-members $25 per webinar for most of the webinars we'll be hosting. And to check on your member status or to become a member, please email info@housingalliancepa.org or call 215-576-7044. Lastly, we'll be presenting our 18th annual Homes Within Reach conference. This year, it'll be in Hershey, Pennsylvania again, December 7th to 9th. And the theme of the conference will be ensuring equity in housing. The conference will be at Hershey Lodge, and we'll be adhering to all CDC and state guidelines in effect at the time of the conference. In case you missed it, we have released some following resources and materials. First, our interactive report on eviction data filed in Pennsylvania, as well as our gathered resources on eviction prevention and housing law. That's all available on our website, housingalliancepa.org. You can also find our 2022 policy agenda there. And with that, I'd like to hand it over to Gale to start off.
Thank you, and thank you so much. My name is Gale Schwartz. I'm the Associate Director of Programs and Policy here at the Housing Alliance of Pennsylvania. I'm very, very excited to welcome back Kadeem Morris from Community Legal Services. Kadeem has definitely given his time and talent to us before, and so we're really grateful to have him back with us again. Kadeem is a supervising attorney in the housing unit at Community Legal Services. He primarily provides same-day representation to tenants in municipal court through the Philadelphia Eviction Prevention Project's Lawyer of the Day program. So with that, I am going to let Kadeem get his slides up and running. But in this, brief moment, I'm just hoping that all of you who are with us today can just share with us who you are, what type of organization or constituency are you affiliated with.
There should be a Zoom poll up at the moment.
Seeing a lot of folks from homeless assistance and from legal aid.
All right, let me end the poll in a few seconds and then show you the results. Looks like about a third of the folks are from homelessness assistance, and about a third from legal aid mediation, and about a third from other categories.
Great, thank you. So again, we're excited to have you join, and we are excited to hand it over to Kadeem.
So good afternoon, everyone. I hope you can see the PowerPoint presentation. I have multiple screens, so it's kind of hard to know what you are looking at. But as was mentioned, my name is Kadeem Morris. I'm a supervising attorney at Community Legal Services of Philadelphia. I supervise our lawyer of the day teams. I think the last time I was here, I was still actively a lawyer of the day, but now I'm actually supervising most of the lawyer of the day teams through the Philadelphia Eviction Prevention Project. And I'm here today to talk to you about our lawyer of the day model. I see that we have representatives mainly from mediation groups and also, I would say, homeless advocates and tenant attorneys, which is great because these are the people who I like to talk to about this issue and explain why it's important, why it's relevant, and kind of get your ideas and information about things that we could do better, things that we are doing differently, or challenges that you are seeing in your communities when it comes to starting a program like this. So I would encourage you to use the Q&A feature liberally so that we can address issues as they come up, and of course, engage in some sort of exchange. I know this is a webinar, but it's great when we're talking about doing something that's considered innovative to have your voices in the conversation and learn from each other as we go along. So I will be presenting on our lawyer of the day model here in Philadelphia. I'm not going to be talking at you for a very long time because I would like to encourage us to talk about it and talk about what issues can exist in your communities. I know that Philadelphia is a unicorn in Pennsylvania in terms of the way a lot of things are done. So hopefully this model can be used in some way to duplicate services, or at least provide a foundation for a conversation for us to talk about what this program can look like in your various areas of practice. So I'm going to try to advance my slides. And I think that worked. So the role of the Lawyer of the Day program. The Lawyer of the Day program is a part of the Philadelphia Eviction Prevention Project, which is a collective of tenant-facing services that are existing in Philadelphia. So just for a brief history of how we got here, in 2017, I believe Matt Desmond published a widely popular book called Evicted. And as a part of that book, he highlighted or zoned in on evictions in Philadelphia and what that crisis looks like. And that really prompted the city to take action and create the Philadelphia Eviction Prevention Task Force. And the task force commissioned a report that was done by Stout that looked at what are some possible ways that we can address evictions in the city. And what came up, which is what I think has been floating around since I was a law student, is that everyone needs to have an attorney, which was usually called civil Gideon. It's kind of now shifted to right to counsel as a movement, but the civil Gideon conversation came to the top. And as a part of the city's experiment with that, we created what's called the Lawyer of the Day program. So the Lawyer of the Day program provides same-day legal representation in municipal court for tenants facing evictions. Now, when I say same-day legal representation, that does not mean that you come into court today and your case is automatically resolved today. There's not that sort of pressure on a tenant engaging in the court process. It means that a tenant can show up to court today, not having previously spoken with an attorney or a legal services agency, and seek legal representation at that time from a legal advocate in the courtroom. So the program is staffed by attorney paralegal pairs in Philadelphia for each listed in municipal court. In Philadelphia, landlord-tenant court is centralized in one location at 1339 Chestnut Street. So it is one building, one courtroom that handles all of our eviction cases. So tenants can show up to court. There is a morning and an afternoon list. So a tenant can show up to court at the time of their listing and seek out help from the Lawyer of the Day program. The way it really works is that you come into court, it's a big courtroom, everyone checks in and is usually seated in the courtroom. I'm going to talk a little bit about a Courtroom Navigator, which I think is an important aspect for this program when you're operating in larger volume spaces. Typically, we see anywhere from 100 to 150 eviction cases in a day. So an attorney and paralegal really cannot communicate with everyone and also attempt to provide legal representation in that space. but we just wanted to kind of have that service in court available to mediate some of those questions, although mediate is not the right word to use with mediators, but to kind of triage some of the questions that may potentially come up. So at the time of the hearing, the lawyer of the day staff completes an intake for a tenant and does a case consultation to determine eligibility for our services, because there is an income or eligibility criteria, and then decide what the appropriate next steps are in every case. So how does the Lawyer of the Day program get staffed? Essentially, there is an attorney paralegal pair at every list. There's an AM list at 8:45 and an afternoon list at 12:45. And an attorney can take up to 5 unrepresented tenants on any given listing. So it's a total of, volume-wise, it's a total of 10 tenants who can be represented in any day, or 10 households, however we would like to count them. Usually it turns out to be about 3 or 4, depending on the complexities of the cases and whether or not the case can be resolved on that day, or if it takes and requires additional steps for ongoing representation. Some organizations pair teams with an attorney paralegal and an attorney paralegal pair. Some do attorneys with law student volunteers who do the intakes at the time of the court case. A tenant can either seek out representation themselves if they have been made aware of our services. So if you call, let's say, our hotline within 24 hours of your hearing and say, I need help with this, they will refer you to the Lawyer of the Day program in court for the next day. Or if you come into court and the court does an announcement, so it took a lot of work to get here, but at the start of every list, there's a trial commissioner who comes on the bench and essentially reads general information about court cases and lets tenants and landlords know what services are available in court. As a part of that, there is an introduction to the fact that there's a Lawyer of the Day and a Courtroom Navigator present in the courtroom. And at that point, the tenant can self-identify by raising their hand and asking to speak to the Courtroom Navigator that they would like to be paired with the Lawyer of the Day for eligibility screening and representation. I see that there is something in the Q&A, how many attorney paralegal teams are needed to cover all shifts. As of right now, so there's a morning and afternoon shift every day of the week. We have 1 attorney paralegal team for each shift. So that is about, wow, math is hard. That is 10 shifts that are covered. We do not actually have 10 attorney paralegal pairs. What we do is there are 3 agencies that staff the Lawyer of the Day program. It is primarily staffed by CLS. We cover about 75% of those listings. And we also partner with Senior Law and Legal Clinic for the disabled, and they cover a list each. So we have about, at CLS, we have 3 attorney paralegal teams with me, I think, covering a list twice a month in addition to those teams. And they cover about 2 to 3 lists per week. And then LCD and Senior Law each cover lists for themselves. So I think it can vary. You can have 10 individual teams, but based on the way the lists are split, we have about 5 teams that cover roughly 2 lists per week. And they do that on a weekly basis as long as the court is open. So a big part of the Lawyer of the Day program is an eligibility criteria, because fortunately or unfortunately, tenants come into the courthouse at every end of the income spectrum, and not all of them are eligible for our services. And because we are largely legal aid programs that are providing this work, we have to ensure that the services that we are providing within the Lawyer of the Day program does in some way conform to funding requirements or just our general practice requirements. So for the Lawyer of the Day program, the eligibility criteria is that the tenant be a resident of Philadelphia, that they have an eviction case in landlord-tenant court, which is part of the centralized Philadelphia municipal court system. It's the equivalent of the MJD levels out in the county. So Philadelphia City and Philadelphia County are one and the same. So our courthouse is centralized. So we have one courtroom 3, where all the landlord tenant cases happen, and they have to have a case at that level. They also have to have income at or below 200% of the federal poverty limit, or 80% area median income, depending on the type of case and funding stream. 80% area median income is quite high. So that's maybe something that's a little different than what you're used to. We say low standards for determining merit, and by that, I think we mean, is there a better outcome that we can help the tenant achieve than they can otherwise achieve by themselves? And I say, is there a better outcome? Because not every case is appropriate for trial. Not every tenant actually wants to go to trial before a judge. Sometimes they just want to negotiate an agreement that helps them to preserve their housing. But at the same point in time, they want to have the reassurance of having spoken with someone who is an advocate or on their side to answer any questions that they may have about the court process. So all eligible clients that come and self-identify are seen by the lawyer of the day, up to 5 cases per list. So in a day, to kind of also answer the question that's in the Q&A, in any given day, 10 clients or 10 households are represented by the lawyer of the day program. There are times when, because we've built an existing or ongoing relationship with the court, that the court may ask us to speak with additional tenants who the court identifies as being particularly at risk or in need of additional resources and help from the program. And we do speak with those clients. So sometimes we may go over that 10 and do maybe 12 or so cases in any given day. But usually we do that. We don't go into the middle of a trial and take a case from the court. We usually do that with the agreement that there will be some sort of continuance granted to the tenants so that we can speak with them properly, evaluate their case, and get additional resources to them as may be deemed necessary at the time of the intake. So what does the workflow look like in the lawyer of the day space? So there is a referral or self-identification that can be done either in advance of the court date through the hotline, or it can be done in court after the trial commissioner has made everyone aware of the existence of the lawyer of the day. So as I kind of described it, one big centralized room in Philadelphia, the courtroom navigator and the lawyer of the day are generally at the back of the courtroom at the call of the list so that they can self-identify themselves to tenants when the trial commissioner makes the announcement that there is a lawyer for the day and a courtroom navigator available. If a tenant self-identifies and asks to speak with us, they are then noted on the court's list that this person is speaking with the lawyer of the day so that they cannot be defaulted while they're having that consultation, and they are taken to the back to do an intake. And then we have case consultation where the attorney meets with the tenant and evaluates their case. And then there's the representation decision, which is almost always, we will accept your case so long as you actually live in Philadelphia and are within our income guidelines. Just for a bit of context on the Philadelphia space, so because it's one courtroom and there are 2 lists, the way the court operates is a trial commissioner comes out on the bench at about 9 o'clock, 9:15 actually, half an hour after the 8:45 listing or half an hour after the 12:45 listing, which I believe is 1:15. The trial commissioner will come out on the bench and then make these announcements and then start to process cases. So in Philadelphia, we have about 19,000 pre-pandemic eviction cases per year. So it's a significant volume of cases that are going through any listing at any given time. So the attorneys who represent landlords all have to sign in as they come in, and they can have anywhere from 1 case to 40 cases. And they pick a time slot on the list, and the trial commissioner essentially calls up an attorney and the attorney goes through their list. So if an attorney has 20 cases, they will go through their 20 cases. So if one of those 20 individuals identifies themselves as wanting services from the lawyer of the day, we have to notify the court that we will be speaking with that person so that as the attorney is going through their list and calling out what are going to be potentially default judgments for people who are either not present or not present in court at the time of the list, that they don't get defaulted. So that's kind of why it's important for us to have both Courtroom Navigator and the Lawyer of the Day team present at the same time, because of the volume of cases that go through, and the fact that if you are late or not present in the room at the time of the listing, you can get a default. So I'm seeing a question in the chat that says, what happens if more than 10 families or 10 people identify themselves at the same time, at the time of the hearing? Honestly, we generally try to stop at 10. Well, it would be 5 per list because it's 5 in the morning and 5 in the afternoon. But there are instances where, based on our working relationship with either opposing counsel or the court itself, we would generally advise that tenant at that point in time when we're at 5 to go to the court. If it's your first listing or second listing, ask the court for a continuance in your matter so that you can be connected with counsel. And then the lawyer for the day will represent to the court that we are here today, but we're already at capacity before the day, but we will speak with this tenant if the court grants them a continuance, so that we're not required to do more than our 5 cases in that time frame. So just for a sense of what it looks like, there's an 8:45 list that starts at 9:15, and then there's a 12:45 list, and there's generally a break between both lists. So if you think about working with 5 different tenants from the point of an intake straight through to representation in approximately what feels like under 2 hours, or just about 2 hours, that is a lot to get done in that time frame. So the 5 cap is also one, to make sure that we don't commit malpractice by not actually speaking with individuals, and also to ensure that tenants who we are meeting in this space have some sense of dignity, and not that they're being pushed through the court process in a really expedited way. It is expedited, but we want the tenant to feel like we can at least take some time to sit with you, talk to you, and get a meaningful understanding of your issues. Of course, the Lawyer for the Day is not, the goal of the Lawyer for the Day program is not to replace the traditional representation model, but it's to provide an additional avenue for tenants who would have not otherwise been able to access the traditional representation model, where they meet with you well in advance of their hearing, and they can present to you, and you can talk for sometimes an hour to 2 hours during a traditional intake and get all of that information. In the absence of being able to do that, there's this more condensed process where they meet you at court. You talk to them for roughly 20 minutes to half an hour about their case, and there's some sort of decision made as to how to proceed. And that doesn't necessarily work in every case, but it's generally the model that's adopted for people who have otherwise not been able to access our representation prior to the Lawyer for the Day. So we were talking a little bit about the Courtroom Navigator. The Courtroom Navigator is an impartial court resource that's provided through the Philadelphia Eviction Prevention Project, and they are crucial to the success of the program in the way our courthouse is set up. So the Courtroom Navigator can connect tenants with legal representation through Lawyer of the Day, refer tenants to financial counseling, and answer questions that the court staff cannot answer. So part of the large problem of why there's a need for this program is that court staff generally are not allowed to answer any questions that can feel like giving legal information or legal advice to tenants. So a tenant may have gone through a court case and gotten a judgment or signed an agreement, and then their first question to the court staff is, well, what does this actually mean? And the court staff cannot address any of those questions. So the Courtroom Navigator is a point of triage where they can decide, does this person need to speak with a lawyer before they take next steps? Or is there questions that we can answer and then refer and connect them to other resources that can be helpful? So we do have a network of services here in Philadelphia that can help a tenant. So if there's an agreement that's already made or a judicial decision that has happened, they can be connected with those resources or referred for follow-up legal representation if the case has already happened that day. What happens if a landlord has multiple evictions? Are you able to work with all of their clients on a particular day? Sometimes we work with multiple clients from the same building or the same attorney on any given day. We don't usually, it doesn't happen often because tenants generally self-identify as to whether or not they want our help. And because of the way the list operates. Now, if one of the larger attorneys goes first in any given day, we're likely to get more than one of their cases because they will come in sometimes with 25% to 50% of the caseloads that are happening on that list, whether it's morning or afternoon. And sometimes those attorneys themselves will direct their clients, not their clients, but tenants who they perceive as to be in need of legal assistance to come talk to us before they resolve their cases. So we can do that. And if it's the attorney themselves who are directly referring the cases to us and we are working with other tenants who might be from other landlords or other attorneys, we will often go to that attorney and say, I understand you're referring this case to us for legal representation. This is a first or second listing. We would like a continuance in the matter so that we can talk to this client more and further evaluate their case. Now, why does this even matter? I would say sometimes these cases are subsidized housing cases. Like there are attorneys who almost exclusively represent subsidized housing providers. And when they come to us with a case and it's a lawyer of the day case, most times we need additional time and additional information. One, to add the housing authority to the case so that all interested parties can be represented, because unfortunately landlords are allowed to file, especially in voucher cases, against the tenant without actually filing against the housing authority. So sometimes we get a continuance to bring the housing authority to the table. Also, most tenants do not, there's nothing in the manual when a tenant gets served with court papers that says you have to bring every piece of documentation related to your case to court with you. And a lot of tenants don't actually come to court with a lot of the documentation that they need in complicated subsidized housing cases, like rental addendums. Sometimes they have proof of recent payments, but the late fees or ongoing balance might have been triggered for something that happened a year or two ago that they don't have immediately in front of them. So we do, when we're working with people who are in the space on a consistent basis, identify to them that we are willing to work with this tenant. We need additional time to evaluate what the options are for that tenant or what the appropriate next steps are. And we do tend to do that in cases where it's not necessarily just private housing, where there's a subsidy available either through a voucher or through subsidized housing through the housing authority. We identify to those landlords as early as possible that we're going to need additional time on this case to work with the tenant to get to the bottom of what the issues are. Because sometimes it can be as simple as the tenant failed to recertify and the case is in court because of that issue, and the landlord is proceeding with an eviction when the tenant has actually submitted all of the required paperwork to the housing authority, and the housing authority has just not taken the necessary steps. And all two of the people in that three-way relationship, which is often the case with the housing authority, are speaking to each other, but the third person is not in that conversation. So bringing them in can often lead to the best outcome. So just to talk through what the client experience is at the Lawyer of the Day program, there is the intake that is done on site in a different room in the courthouse. So there's a general courtroom, there's the attorney negotiation area, which is just off the courtroom. And then there's a Lawyer of the Day room where we can go and have a private client consultation, collect documents, scan through intakes, look at income information. And all of that must happen pretty quickly, unfortunately, because of time constraints. So it's something that our staff has gotten pretty good at being able to do. Fortunately for us, sometimes it does take longer because some clients need additional supportive services to get through that process, but it generally takes about 20 minutes. Lawyers generally request continuances in complicated cases. If the case is at the point where it is not continuable or the other party opposes the continuance either because it's been continued multiple times, or there might be a breach related to violence or threats or something else that is alleged on the complaint, then that case will go to trial that day, at which point we usually either reduce the number of cases that the lawyer for the day is taking on that given day. So let's say a client comes to us, it's a third listing, it's marked must be tried defense, meaning that the defense is not able to request any additional continuances from the court. And this is the first time that the tenant is being connected with resources. And let's throw in the additional wrinkle that it's a subsidized housing case where the landlord is alleging that there have either been criminal activity or threats made against the landlord by the tenant or a guest of the tenant. That is a case that we would prioritize above all other cases because there's a voucher or subsidy there that once lost is generally not something that the tenant can get back. So that is a case that we would prioritize, and that might result in us taking less cases on that given day based on an attorney's experience and capacity to deal with those cases. So it does ebb and flow and vary because we do want to make sure that the most vulnerable households are being served and protected through the program and not helping that person when they could potentially lose a voucher because we are going to help, let's say for other cases that we might be able to get a continuance in or some sort of a understanding with the opposing party that we will help them. We just can't help them at this very moment. It does not seem like the appropriate way to get that done. So I believe this is what our decision tree or representation chart actually looks like. So there's the referral done by either the tenant self-identifying and determining that they would like our services. Then there's a representation conversation where there's a case consultation, the review of documents if the case is going to happen at that very day. And there are options in municipal court. There is the continuance to get additional time and resources for extended representation, which is the preferred part for complicated cases or cases that involve subsidies or the third parties who have not self-identified them, have not been added to the complaint or present at the court with the information necessary. There is the trial option, which can feel a little hectic, full disclosure, if you're doing this after meeting someone for half an hour, but sometimes by the grace of God, tenants do actually show up to court with all of the necessary information and all of the paperwork that the team needs to evaluate their case, and they can quickly see what needs to happen or what's the best way to proceed with the case. And if a case goes to trial, there's the potential for the appeal representation. Now, there's not an automatic right to representation in appeals cases, because unfortunately that would be unwieldy if we had to represent in every case that if we had to represent at the appeal stage in every case that we tried, that would create a large backlog of cases for a team that is unfortunately in court multiple times a week on cases. So we don't automatically take appeals, but where there's merit to the appeal, this is one level where there is some sort of review to determine whether or not the judge made the completely wrong decision. And of course, appeal is de novo to the Court of Common Pleas. So we would take that case if there's merit to the appeal. Otherwise, we give the tenant advice on how they can get connected with counsel for an appeals process, and also give them advice on how to file that 10-day appeal notice in court. There was something that I wanted to say at this stage. So in our courthouse, there is as I'm sure everyone is aware, or most people should be aware, a case can be filed for non-payment of rent, breach of a lease condition, or termination of term. In Philadelphia, in addition to the defenses to non-payment of rent, of habitability, implied warranty of habitability, and unsafe living conditions, there's also a good cause law, which requires that a landlord who is trying to terminate a short-term lease or a lease that is less than a year provide a tenant with a notice of good cause, which informs the tenant that they have the right to go to the Fair Housing Commission and challenge the landlord's assertion of good cause, which is generally that they're selling the property, that the property is in need of repairs that requires the tenant to be removed from the property to make those repairs, serious habitability issues, or that they're moving a family member into the property and no longer using it as a rental property. The tenant has the right to challenge that assertion within 15 days of receiving that notice. And there's also the requirement for the landlord to have a renter's license that is valid and correctly identifies the number of properties or units that are in the complex that they are renting. And there's also a certificate of rental suitability that is required for renting all properties in Philadelphia. Now, full disclosure, the agency that is set up to investigate or make sure that these properties are habitable does not actually investigate or look at the properties before the licenses are issued. So you can get a renter's license by paying the fee online and properly identifying your property, whether or not it was built before 1978, which would then trigger the requirement for you to have a lead license or a lead safe certificate from the city, which will require you to have an inspection done to make sure that there's no lead paint or lead paint chips or residue anywhere in the property. Previously, that law only triggered for properties where children 6 and under were present. Now it's the law in the city that all properties built before 1978 have to have the certification that they're lead safe, which I think is a much better standard than waiting for it to be just triggered by the presence of a child at that very moment. So there are all of those, I would call them triage points, or points where there's the opportunity to have a case withdrawn or removed from court for failure to comply with those rules prior to filing. So in municipal court, when a case comes to court and there is failure to comply with either the lead safe law, the rental license law, or failure to have a valid certificate of rental suitability, the court will issue what's called a notice of non-compliance, which highlights which of the laws the landlord is not complying with, which in most cases is an automatic defense to any claims for possession or rent owed in that time period. So there is the ability to somewhat triage cases in a faster manner based on the information that's in the court filing than actually looking at before you get to the point of, is there a defense to non-payment of rent? So the initial conversation when an attorney gets referred a case on the list is the landlord in compliance with the filing requirements in the city of Philadelphia? If yes, then you move on to, are there defenses to the allegations of non-payment of rent or termination of term? For termination of term, has the proper notice been provided to the tenant that they have the right to challenge the allegations of good cause to terminate their lease? If it's a lease less than a year, if it's a lease of a year or longer, is the landlord in compliance with what's required under the state law or under the lease itself? And then we kind of triage from that way and go to the broader defenses to non-payment of rent or breach of a condition. So there is some, over time, as you learn, there is some ability to kind of wade our way through cases without first having to ask the tenant any information about their case. So if we can get the case dismissed or withdrawn because of that, we will do that in advance, and then we will consult with the tenant and give them information or resources about what the landlord needs to do before they bring the case back to municipal court, assuming we get it kicked out on those initial non-compliance issues. If it goes beyond that, then we determine whether or not this is an issue that the client wants to take to the trial with a judge, or if there is a different resolution, sometimes by negotiating a judgment by agreement, which can be monetary or non-monetary. Sometimes those judgments are simply behavioral agreements where the tenant agrees to refrain from a particular course of conduct or have their guests or others refrain from a particular course of conduct. Those are more common in the public housing space where there is some sort of a additional party or entity that is operating. Sometimes there's case management requirements or other things that the tenant is required to comply with outside of the general terms of their lease agreement that would require them, or that would place that additional restriction or limitations on certain behaviors and activities that may have happened or are happening at the property. So that is kind of an explanation of how we would somehow triage a case out before it got to the question of, is this a case with a triable issue on non-payment of rent, in terms of, are there habitability issues in the property that need to be addressed? Or are there issues, is the breach an actual breach? Has the breach been remedied? Was there proper notice provided to the tenant? There's kind of that additional stage of compliance check based on Philadelphia laws that slows down the court process. I'm actually curious if anyone from any of the other counties can let me know if there is any sort of housing code enforcement agency in your counties, or if there's any sort of requirement that prior to a landlord entering into a landlord-tenant relationship with a tenant, that they have to get certain documents from the city that specifies that the property is fit for human habitation, or that they're in compliance with renters. I mean, the compliance requirement is that you get a renter's license, or that there is a renter's license requirement prior to you being able to rent and collect rent in the city. And if there is the equivalent of, let's say, a Fair Housing Commission, that is essentially the first stop for a tenant to review habitability issues with their landlords before they get brought to municipal court, which is our equivalent of the MJD level in Philadelphia. So if anyone could pop that information in the chat really quickly, I would be happy and curious to know where we are. And I'm also curious to know if there is anything that I have said so far that does not feel adaptable to any of your locales or modes of client representation that exists currently.
So I think I have a couple of questions, just kind of clarifying. So again, when determining eligibility, you're kind of going on people's good word, right? You're not requiring documentation or anything like that.
So our eligibility requirements for this program mirror the eligibility requirements for CLS as a legal aid provider. So to the extent that someone can prove that they, let's say, get Social Security or has a pay stub with them, we accept that, but we don't require any additional proof of that income beyond that. Now, when someone comes in and they're in subsidized housing, that is almost automatically a confirmation of their eligibility for the program. But people generally, we do self-attestation of income, which is what's allowed in our funding source. So this program is actually funded by the city of Philadelphia, which I think creates some additional flexibility in what's required in terms of income documentation for the program. And if there's ways to verify like the receipt of public benefits and other assistance that can be verified through the city in terms of eligibility requirements, but we don't actually require someone to have that information at the time that they come to court. So there's the ability to do that.
Great, it looks like we have somebody shared from Allegheny County. There is technically a requirement for an occupancy permit. However, the enforcement is spotty, and many different boroughs have their own code enforcement agencies with varying levels of strictness and practical enforcement.
So I would say that the occupancy permit in Allegheny County sounds like a renter's license in Philadelphia. As I said, there's no pre-inspection done of the unit before these licenses are issued. But if there is a problem in the unit, the License and Inspections Department of the city is supposed to come out within 30 days and do an inspection and issue violations or some sort of report, that should then be almost a rubber stamp for the court that there is a habitability issue in the unit in question and that the tenant has the right to withhold rent. Now, I would argue that just that issue being flagged by the city is notice to the landlord that there's a habitability issue and the tenant shouldn't have to do anything additional to withhold rent at that point in time. Now, of course, most judges will say, well, the tenant still has to notify the landlord in writing and give them the opportunity to do that repair before they can do that. But that's just one of the systems that works with varying degrees of success in Philadelphia as like an initial triage point for a case that would come to the lawyer of the day.
I'm wondering if you could talk a little bit about the funding for this, who seeded it and, how has it grown and been sustained?
So I did not include a slide on funding because funding for this is a bit complicated. So the Lawyer of the Day program is housed within the Philadelphia Eviction Prevention Project, which is funded by the city of Philadelphia. Initially, the project started out with about $500,000 of funding, which funded one lawyer of the day on one listing. And then it grew from that point to, I think we're at about 3.5 million in this program. And that funds both citywide representation. So for those clients who can't get help through the Lawyer of the Day, they can contact our hotline and get referred to our legal services partners, which are CLS, Senior Law Center, and LCD for representation. And it's the same income threshold and eligibility requirements that exist for the program. They can get representation through that. I would call it that advanced interaction with an attorney before you come to court for the Lawyer of the Day, or they can get come into court and they get a continuance and they're referred back to us. They can get representation through us, representation through our pro bono partner, which is Philadelphia VIP. They do pro bono representation when the other agencies that are involved can't help. So the Philadelphia Eviction Prevention Project has about a $3.5 million budget, which includes funding for Right to Counsel, which is a new program that is, I think, a little bit more targeted in the city of Philadelphia, where we do representation for all cases in 2 particular zip codes with the potential to expand that beyond where we are at this point. So that is all encapsulated into that large funding pot. So it's kind of hard to slice it and say that this $1 million represents this program. I would say we do budget on a 5 case per shift manner of calculations of what our output expectations are for the city, but we don't have, I can't break out that number because of how things shift around of what the actual cost of this program is. So I would say whatever the cost is that an organization is charging per case, or the number of cases that they anticipate that they would be able to do in any given day, shift, or week, is what the metric would look like for duplication purposes. I saw 2 raised hands, but I'm not sure if there were questions. I don't actually know how to use the raise hand feature.
Yeah, if you, whoever raised their hands, if you could type in your question to the Q&A. We did have one come in through the chat. Does it matter if the habitable condition was caused by the tenant since no pre-inspection was performed?
So there's no pre-inspection for a landlord to get a renter's license in the city of Philadelphia, but generally speaking, there is some sort of walkthrough that is done with a tenant at the time of lease signings, and most model leases includes a provision that you're accepting the property as is. So if there is damage that is done within that time window that's not attributable to normal wear and tear, like if the ceiling falls in because your bathtub on the 2nd floor overflowed because you left it running, that's something that I think can be pretty easily identified as a tenant caused issue. Now, if your ceiling falls in because your neighbor upstairs has a plumbing issue that your landlord has not repaired, and you can see like the the staining on the ceiling from where the leak was, that is easily to identify as a non-tenant caused issue. So that's, I would say in that instance, it does matter in terms of determining who's responsible. But generally, once a tenant moves in and signs and accepts the conditions of the property at the time of move-in, if something happens that is readily attributable to, like a hole in the wall where you can see that a fist was punched into the wall, is probably going to be attributable to a tenant. But like paint falling in from the ceiling, or the gap that sometimes happens in your window frame after it's been there for too long, those are non-tenant caused issues that are generally referred to as normal wear and tear. And anything beyond that becomes a determination for the court to make. I would say the longer a tenant lives in the same unit, like for some of our subsidized tenants, they have been in the same home for 10 to 15 years. At that point, any repairs or things that happen in that unit generally should be considered normal wear and tear first, unless there can be proof that there was an inspection done and this is a new issue that comes up that has not been, that cannot be attributable to the time or breakdown of the property. I would say something like a broken door where a door is kicked in is going to be attributable to the tenant or to some sort of activity in the unit that's not normal wear and tear. But generally speaking, the longer you're there, the more likely that it is that these issues were caused by normal wear and tear. So to answer the question about invoicing, our city contracts and most contracts in the city of Philadelphia work on a reimbursement model. So if the 3.5 million that's allocated to our program is allocated as a part of the city's budget, and then we work on our cases at whatever the exact billable rate is per case that is charged. And then at the end of every quarter, we submit invoices to the city, and the city then reimburses us based on what's allocated to us through that model. It may vary depending on your city's process, and there's not a specific, well, in terms of a specific number of attorneys, it's not going to be more attorneys than are covered in the Lawyer of the Day program. But because we have other programs built into our contract, it can be as much as 50% of the work in the housing unit or less, depending on what other funding sources are in existence at that point in time.
I have a question about how many people have you served in a year through the Lawyer of the Day program? I mean, if you have, what is it, 5 days a week,
So
10 shifts.
I have a metric slide that shows what we have done so far. So the Lawyer of the Day has been in existence since 2018. And so far we have represented nearly 3,000 tenants or 3,000 households, 2,764 cases to be exact. And that ranges from a case that is resolved that very day that you meet a tenant to a case that goes on for 3 to 4 months where there's a complicated subsidized housing issue. And in 2021, in the height of the pandemic, we actually did 647 cases because the Philadelphia Municipal Court decided that they were only going to be closed for a few months and reopened quick, fast, and in a hurry. So in 2021, we actually represented 647 tenants through this program. We are likely gonna either meet or exceed that number for this year, just because of the fact that the court's gonna be open for the full year, and we are actually at full capacity in terms of all of our shifts are staffed, and we have additional cases that are coming in through rights to counsel. I wanna quickly there's a question in the chat about if there's a document that entails responsibilities and landlord responsibilities and legal documents that a landlord must use to operate legally. So in Philadelphia, there's what's called the Good Housing Handbook that a landlord's required to provide to a tenant at the time that a lease is signed. So you get your lease, you get a copy of a valid renter's license, and you get a copy of a certificate of rental suitability. None of those two things require any inspection before they're issued. They're just issued pro forma. And then there's a booklet that goes with that. That is called the Partners for Good Housing Handbooks that list all of the requirements and laws related to housing in the city and resources that tenants can have access to. The landlord is required to provide all three to a tenant at the time that the lease is signed. Some tenants get them, some tenants don't. Usually it does not become an issue. The handbook is online. I think it might also be at phillytenant.org. I'm going to put the website, our website, in the chat for people to go to. That is a tenant-facing website that is run by the Philadelphia Eviction Prevention Project. We have a resource library with every sort of, with a flyer or an article on every sort of document or filing that a tenant would need. We have appeals rights, security deposit resources, all there. We also have videos explaining tenant issues on that website. And I believe this presentation will be made available to participants through the Housing Alliance. So you will get all of these resources, but that's where they are. As to why pre-inspections are not recommended, I honestly do not know. It would be great if before someone rented you a property, the city actually sent someone out to inspect the unit to make sure that this certificate that they are issuing actually means that the program is suitable. I believe it's a capacity issue with the city because there are way more rental units than there are inspectors, and the inspectors theoretically pre-COVID and at some point during the COVID season will inspect once you report a problem to them. I would say things like not having a working heating system and major leaks or exterior issues are things that are prioritized by the agency. So they will come out for those things in a more speedy fashion, but generally speaking, they have 30 days to come out and get you scheduled and inspect the property. So it's a check on the landlord, but not a pre-check before you go through.
All right, so we are at 2:59. I want to thank Kadeem so much for a really, really great presentation and for everybody who put forth some really thoughtful questions. I think we had a great conversation today. We will be sending out a copy of today's presentation, PowerPoint, any additional materials. We hope that you can join us a week from today for our next webinar, where we're going to be focusing in on eviction diversion programs in Chester and Berks County. And of course, after that, we'll have a voter registration initiative webinars. So thank you all, and please enjoy the rest of your afternoon.
And just in closing really briefly, my contact info is in the presentation. If anyone has any questions or wants to talk offline about duplicating this type of program, we are happy to be a resource and support.
Thank you. Thank you so much, everyone.
Thanks.